If you're in Australia on a valid visa and you fear what could happen if you return to your home country, this video is for you. Applying for Protection Visa Subclass 866 is one of the most serious and life-changing applications in the immigration system. The decisions made throughout this process, starting from day one, can determine whether you stay in Australia permanently. In the next few minutes, I'll explain how this process works, what you need to know before you proceed, and what to watch out for along the way. The Subclass 866 is a permanent protection visa. It's for people who are already in Australia and arrived on a valid visa that includes student visas, tourist visas, work visas, and other temporary visa types. If granted, you become a permanent resident immediately. To qualify, you need to engage Australia's protection obligations. That means demonstrating either a well-founded fear of persecution based on your race, religion, nationality, political opinion, or membership of a particular social group, or that you face a real risk of significant harm if returned to your home country. The application is lodged using Form 866, which includes a detailed personal history and, most importantly, your protection claims. Once lodged, you'll generally receive a bridging visa that allows you to remain in Australia lawfully while your application is assessed. The department will assess your claims. In most cases, this includes an interview where a case officer will question you directly about your situation. The officer may also request additional information or documents, and in some cases there can be more than one interview before a decision is reached. There are 3 things that must all go well for a protection visa to be approved, and all 3 need to be at their best from the start. The first is how you answer the protection claims section of the Form 866. These questions ask you to explain in your own words why you left your home country, what you fear will happen if you return, whether you experienced harm, and whether the authorities there can or will protect you. We see many applicants give short, vague, or incomplete answers. That is one of the most common reasons applications are refused. Every question in this section needs to be answered carefully, fully, and with specific details that support your claim. The second is your evidence. Every claim you make needs to be supported by documents, reports, photographs, statements, or other materials that corroborate what you said. The third, and the one that catches people off guard, is the interview. The department's case officer will ask you direct questions about your claims, your history, and your circumstances. You need to answer clearly, stay focused on the question being asked, and be consistent with what you've put in your application. We have seen many applicants who had genuine claims refused at interview because they couldn't answer clearly under pressure, gave inconsistent information, or went off topic. All 3 of these elements need to work together. A strong application with a poor interview or supporting evidence can still result in a refusal. We also strongly recommend engaging a lawyer with years of hands-on experience specifically in protection visas to prepare a legal submission with your application. It is worth noting that most Australian migration lawyers do not regularly handle 866 applications and do not have this depth of experience. A lawyer who knows this visa well will be able to present the legal arguments for why Australia has protection obligations to you, address any weaknesses in your claim, and present your evidence in the context of Australian migration law. A well-prepared legal submission can be the difference between a grant and a refusal. If you're thinking about applying for protection visa, or if you've already lodged and want to make sure your claims and interview are as strong as possible, the time to act is now. At MML, our lawyers have successfully handled hundreds of protection visas. We offer a structured protection visa service that covers all aspects of the application, including assistance with preparation and lodgement of your application, gathering and organising your evidence, drafting a legal submission, interview preparation sessions with you before the interview, and attending the interview with you on the day. Having a lawyer by your side at interview makes a real difference. You can focus on answering the questions while we make sure the process is conducted properly. Before you engage any migration lawyer, there are a few things you should watch out for. Some firms will pressure you to sign on the spot. They'll offer discounts, create urgency where there is none, or find other reasons why you should commit before you've had time to think. These are sales tactics. Any firm that needs to rush you into a decision is more interested in your fee than your visa application. At My Migration Lawyers, we do the opposite. We give you a 2-day cooling off period and send you a complete information pack of 7 documents before you make any decision, covering fees, refund and complaints policy, service commitments, and your rights as a client. You read everything at your own pace before you commit a single dollar. Once you engage us, you get regular updates at every stage. At MML, your rights come first. Book a consultation with one of our migration lawyers. We'll assess your situation, give you realistic advice, and tell you exactly where you stand. Let us show you the MML difference.